Well, hello there, and welcome to another edition of the Employment Law Show. Your host, John Scholes, right beside me, Lior Samfiru. Good to have you along for the half hour. The main topic for today will be fact or fiction, maternity and parental leave. That's in just a little bit. That we'll get to some phone calls from one of our many radio shows across this wonderful country of ours. By the way, if you want to tune into a show, find out where one's airing near you, online as well. You can go to employmentlawyer.ca. For all other matters discussed with Lior and his team, you can reach out by phone, 1-855-821-5900. We'll put that up the screen, and I'll reiterate that throughout the show. And help@employmentlawyer.ca is the email address we go to. And I know Lior likes to use and mention pocketemploymentlawyer.ca. You can learn so much by just simply using that free and anonymous website put together by Lior a few years ago. And he's also baked in the severance calculator into that, which does exactly what it's meant to do: calculate the proper amount of severance you should get. If it ever comes down to the time where you're let go from your job, you will be in good hands calculating even your own severance before the phone call. But always feel free to reach out to Lior in any regard. Okay, that's all coming up, pal. But first, the week that was, case of the day. What is cooking for you?
John, I don't know if you can tell, but I'm excited. I'm pumped. I'm ready to be talking about employment law, of course. Such a great topic, such an important topic, and kind of topic that I know something about. So it's a good fit for the show, I think. I've been having a lot of calls at the office, a lot of emails, more than ever these days. So I am so happy to have this opportunity to reach as many people as possible, because you may not understand that you have a lot of rights. So many people, and it's unfortunate, it really bugs me that we have all these rights in this country, employment rights, some of the best employment laws in the world, but too many people don't know them. They walk away from rights. They don't pursue their rights because they don't know they have those rights. Well, if you watch this show, if you watch us on TV or listen to us on radio or watch me on doing live streams, hopefully by now you're getting a sense. Wait a second, I have rights. If I lose my job, if I'm mistreated at work, if my job changes, if I'm misclassified, I have rights. There's things I can do about it. On the show, we educate you on those rights. You need to know. You have the knowledge at your fingertips here. And of course, to connect beyond the show. If you want to have a private chat with me to find out more about your rights, or to get me to help you enforce those rights, we'll give you that contact information throughout the show. You can phone, you can email, so we can have that private discussion. Don't be bashful. I'm here on TV kind of every once in a while. The rest of the time, I'm in the office working hard, making sure that rights are being enforced. So let me start off with the case that kind of, I think, gives you an example of that. I got contacted by a gentleman who told me that his sister was let go recently, and she had worked as a bookkeeper for a large company for over 25 years, and working part-time hours, 3, maybe sometimes 4 days a week, somewhere in that range, and was let go because the company decided to bring in someone else to do the bookkeeping. But this whole time, for over 25 years, she was an independent contractor, they said. She'd send them an invoice once a month. They'd pay the invoice, and on they went. And after 25 years, she was let go, no severance, no compensation. She, the sister, did not want to speak to me, that brother said, because she didn't think there was any point. She didn't know why her brother was bothering talking about this issue. So I spoke to the brother, and I said, you have to get the sister to call me because she's been misclassified. She finally did. And yes, John, she was an employee in the eyes of the law for 25 years. She worked for them exclusively. She worked in their offices. They told her what to do, how to do it. She wasn't someone that was in business for herself. She was an employee. So when she lost her job after 25 years, because she was not a contractor in the eyes of the law, she was owed severance, 2 years severance, 24 months. That's what she was owed. And I am in the process right now of helping her get that severance. So it's pretty safe to say that she is happy that she connected with me eventually, that her brother made that introduction, made that call. I often get calls or emails from someone asking on behalf of their brother, their sister, their father, their mother, etc. Do the same thing. If you know someone whose rights have been affected in the workplace, they probably have a lot more rights than they realize. Make the call. Let me help them. And of course, if you've been misclassified, if you look like an employee and act like an employee, but your employer is saying, no, you're not really an employee, guess what? The law is going to fix that issue and make sure that your rights are enforced.
For the viewers, Lior, that may be thinking, oh, yeah, Lior, I get that. But, you know, they didn't tell me I was an independent contractor. We had a handshake. We both agreed this works better for both of us. It's clean. It's dirty. It's done. We're done. Does that make a difference?
It makes no difference. Think about it this way. If it was that simple, if all you had to do is agree to be an independent contractor, why would anyone be an employee? Everyone can then just be a contractor. Doesn't matter if you work full-time, part-time, minimum wage, well-paid. Everyone can just say, let's just call myself a contractor. Then I can get all these tax benefits. The employer is going to save money too. It doesn't work that way. If you have a job that looks like employment, then it is employment. It doesn't matter what you call it, what someone else calls it, what you sign, what handshake agreement you have. If you look like an employee, as I said, you are an employee and nothing else matters.
What are some of the negative pitfalls to that, I guess, on both sides? I mean, I guess CRA would come knocking, and that could be pretty ugly after 25 years if you've been doing it wrong, right?
Well, CRA is known for not having the best sense of humor. So if, in fact, they decide that you were an employee all along, but you were filing your taxes as a contractor, in other words, illegally, you weren't paying your full taxes because you were getting deductions, again, illegally, your employer, by the way, CRA would find out, wasn't remitting taxes, wasn't remitting EI and CPP, none of that is something that the CRA is going to be okay with. So there's going to be potentially back taxes to pay, fines, penalties, interest. So no, it's not a good thing to call yourself a contractor when you're not. You're taking a real risk, not to mention you're walking away from employment rights that you otherwise would have.
Again, reach out anytime to Lior for more details, or again, pocketemploymentlawyer.ca. There is a section on independent contractors. And employmentlawyer.ca, that website, you will find links to our long-running radio shows pretty much across the country. You'll want to tune in and join in as well. Always an opportunity for you to call into the show and ask your questions. We like to play them back here every week, as you know, Lior. Let's get to our first phone call for this show and talk about it.
I've been working at a company for just about under 2 years, and I went on a 2-week approved vacation. On my return, my services were terminated, as being services no longer required due to business changes.
What kind of a job and how old are you?
I'm 55, and I was in insurance.
So certainly a very unpleasant situation. You go on vacation, vacation is approved, you come back ready to get back to work. Oh, by the way, we're letting you go. And obviously very unpleasant, very unfair, maybe even unprofessional. Ultimately, though, that's not illegal. Your employer is allowed to let you go as long as they pay you proper severance. So as frustrating as this situation is, this issue comes down to severance and how much severance does the company have to pay. If they pay the proper severance, they've met their obligations, except remember, in 90% of the cases, when someone is let go, over 90%, they're not offered proper severance. The company tries to get away with paying less. So let's see how much severance this person gets after 2 years of employment. We're going to go back and use our severance calculator tool. Of course, you can find that at pocketemploymentlawyer.ca. We're going to use that so that you can see how much severance you're owed and how to use that tool if ever it comes down to you losing your job. So we know that this person is in a professional role, been there for 2 years. At the age of 55, we don't know what she's been offered for severance, but what we do know, as you see on the screen, is that she's owed 6 months severance. Now, she's only worked there for 2 years, and you may think, wait a second, she gets 6 months severance after 2 years only? You bet she does. Short service employees are actually treated disproportionately better than longer service employees when it comes to severance. So it's very common, very, very common to have a short service employee that's going to be owed quite a few months of severance. So whether you work for a year, for 2 years, or for 30 years, you got to call me if you lose your job.
Yeah, I bet that employer's thinking, okay, 2 years, week per year, maybe 2 weeks at best. That's what she's going to get offered, not the 6 months. You can almost guarantee it's going to happen, right?
I can almost guarantee it. Maybe she will be offered 2 weeks, maybe 3 weeks. If she's lucky, maybe 4, except none of that matters because as we saw, she's owed 6 months severance. But the good news is, John, it's not going to be difficult to get her that 6 months.
That's right. Okay, phone call number 2 is coming up right now. Lior, let's listen in.
So my employer, the last 16 years, they're basically told me they're moving me out of my current role and want me to move into a different role within the company. Pay, vacation, everything would remain the same. Not interested in taking the new role. Even though they pay everything the same, in my mind is a demotion.
Do you think that others, in the workplace would look at it potentially as a demotion as well?
Correct, yes.
Key piece right there. Yeah.
The demotion is the key piece here. So we know the salary is not changing, the benefits not changing, so that's great, that's fine. The real question is this a lower level position? Is it a position that's going to be seen objectively as a step backwards? Or maybe that's going to cause some embarrassment even in the workplace? What, you were a senior guy, now you're not. Why? What happened? Did you do something wrong? That is not something an employer is allowed to do. If it's a true demotion, so it's not just, well, I don't like the second job as much, I consider it to be a demotion. That may not be enough. Your employer may be able to do that. But if it's a demotion, you were a manager, now you're not. You're in a senior role, now you're not. You were in a prestigious role, now it's not. Well, that is a demotion, and that's not something your employer can do. If you're facing a demotion, even if the pay is the same, you may be able to say constructive dismissal. By putting me in that situation, employer, by demoting me, taking away my otherwise good role, I can treat that as a termination of my employment and require you to pay me my full severance. So that's the option that he has. There's no way to physically stop the company from demoting him. What he can do is consider that to be a constructive dismissal and pursue and get his full severance.
All right, lots more to go, including full call number 3 after the other side of the break. Lior, that and fact and fiction. Fact or fiction, parental and maternity leave. That's all just ahead on the Employment Law Show. Reach out as well by phone anytime. We'll give you that, 1-855-821-5900. Lots more coming up. Stick around. People think you should go to the government to get severance pay. EmploymentLawyer.ca says that is a myth. Government can only help you get minimum severance, but not everything you're entitled to. Always check with the employment lawyer first at EmploymentLawyer.ca. If your long-term disability claim is denied, should you appeal?
Appeals often fail because insurance companies control the process. So long as you appeal, you're playing by their rules.
You should never appeal the denial of your disability benefits. Appeals are just a mirage of false hope.
Don't. That's their process. Take it out of their hands and fight for your rights with our help.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think their employer can make changes to their job. EmploymentLawyer.ca says that is a myth. Your employer can't change your pay, hours, or duties. You may be entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca. Welcome back to the Employment Law Show. Feel free anytime to reach out after the show or any other time to Lior and his team. Always ready for that phone call, 1-855-821-5900. Help at employmentlawyer.ca, and the website is free for you to use as well. There's contact information, plus you'll learn a lot about what we talk about weekly on the show as well, pocketemploymentlawyer.ca. And the radio shows, tune into one, join us, call in, ask your questions, and get smarter that way. As I mentioned before the break, Lior, we're going to get to our third phone call right now. Listen up.
I've worked for an accounting firm for over 20 years. I've got approached by a friend that's doing a startup company. He's guaranteeing me 2 years of work. Let's say my buddy's company, after 2 years, I get fired. Do they have to pay me severance for only 2 years? Because they poached me from an existing career. Do they foot the bill for that as well?
Someone's been watching the show.
Yeah,
Someone's been watching the show.
And someone's got to be very careful here. And here's what I mean by that. So if he's going to start a job that says we're going to hire you for 2 years, at the end of that 2 years, he actually gets nothing because he signed a fixed term contract. So that's not a good thing, okay? Yeah. He should sign an indefinite employment agreement. And then, yes, he could potentially get credit for his service with the previous company. Generally speaking, if you work for a company for a long time and then you're recruited away from to another company, and then in the first few years they let you go, you may be owed enhanced severance that recognizes your service with the previous company. So that's a good thing. But why would you leave a 20-year job to take a job that's only guaranteed for 2 years? Because after the end of the 2 years, if they want you gone, they don't have to pay you a thing. So fixed-term contracts, let's talk briefly about that. A contract for a fixed duration of time. Generally speaking, at the end of that contract, you're not owed anything. If the company wants to let you go before the end of the contract, usually they have to pay you till the end of it. That's a good thing. So depending on your perspective, it could be a good or a bad thing. But I would not leave a secure job to take a position on a fixed term. That just may mean you're going to be out of work with no severance potentially.
And I guess that rule applies, Lior, as well. If you're leaving that job for another job with not a fixed term, but just another job overall, you do not want to sign a contract that ignores your previous service, because, again, that'll cost you tons in severance, yeah?
Absolutely. So if you're being recruited from another job to take on a new position, you have also some bargaining power. You have some leverage here. So don't agree to bad terms. Let me see that agreement. You may be able to enhance severance down the road, so you don't want to sign something that takes that away. Be extra careful about what you sign if you're leaving a secure job. In fact, never sign anything in that situation without me seeing it first.
Okay, super important topic for this week. We'll get right into it, Lior. Maternity and parental leave, fact or fiction. Number one, an employee must announce their pregnancy to their employer. What do you think?
Well, here's the thing. I mean, if you're going to take a pregnancy leave, a parental leave, at some point you're going to have to tell your employer that that's the case, right? So yes, you have to say that to your employer. But what's fiction is that there's a time by which you have to do that, or that you have to announce it right away when you know, or if you're being interviewed and you're pregnant, you have to tell your employer that you're pregnant. No, you don't have to. It's up to you if and when you want to tell your employer that you are pregnant. There's no rules requiring you to tell your employer at a certain time. Once you're comfortable, once you're ready to do that, once you know when maybe you're going to be taking time off, then you can tell your employer, but it's up to you. And your employer may say, well, I wish you would have told me sooner. Well, again, too bad. Or your employer may say, you should have told me that when we were interviewing you. Again, too bad. And an employer that gives you a hard time because you didn't tell your employer sooner, that could be a human rights violation. It's up to you, the employee, if and when you tell your employer about your pregnancy.
Okay, fact or fiction number two, maternity and parental leave is considered a job-protected leave.
That is fact. That is probably one of the most important things about pregnancy and parental leaves. And that's the idea that the time that you are off, okay, that period of time is job protected, okay? That means you have a right to your job. It's not just a leave of absence. Anyone can just go on a leave of absence. But a parental leave is a job-protected leave, meaning your job, well, is protected. You have to have that job ready and available for you when you're ready to come back to work. In some cases, that could be as much as 18 months. So for that period of a year and a half, that job is protected. That may not be true in other leaves. In the disability leave, for example, the job may not be protected. You may potentially lose your job. With a parental leave, that job is protected. You cannot lose the job because you took some or all of your leave.
All right, maternity leave / paternity leave, parental leave, fact or fiction. Number three, Lior, employers can hire a replacement for an employee on maternity leave or parental leave. Can they do that?
Well, yeah, that is correct, because an employer still is allowed to run its business. So if you're going to be off for 6, 12, 18 months, your employer can hire a replacement while you're away because, well, someone needs to do the job. And if the employer decides the best way to fill that position is by hiring from the outside, they can do that. But, and this is the key, once you're ready to come back to work from your parental leave, that employee has to be gone. You have to be given the same job. So maybe the employer decides to keep both of you, that's fine. But your employer cannot decide to keep the replacement over you or to give you a different job because they already have a replacement. So they can hire a replacement while you're away, but it's still your job to have and to take at the end of that leave.
And that's number four of our fact or fiction. Not only do you have to give you the job, but it's the same pay, the same hours. It has to be what you left in the first place, right?
So your job, as I said, is protected. You have to be brought back to the same terms that you had before. Pay, hours, benefits, etc. Everything has to be the same. But it's even more than that, frankly. If the pay for the position, let's say, has increased while you're off, well, you have to get that increased pay. In other words, you can't make less money just because you were on a parental leave. That would be a human rights violation, an employment standards violation. It would be illegal. So pay, hours, location, all those have to be the same when you come back from that leave.
Parental leave, fact and fiction. One more question for Lior. That is, if an employee announces a subsequent mat leave, an employer can let them go.
No. Please don't ever do that. And yes, that happens often when someone is on a leave, on a parental leave, and at the end of the leave or some point after they come back, they say, by the way, I'm pregnant again, I'm going to take another leave. And an employer, it may cause some administrative headaches for the employer, but does not matter. There's no limit to the number of parental leaves, and an employer can never let an employee go because of that fact. Doesn't matter what kind of headaches it may cause the employer. That's why it's a job-protected leave. The law protects that job, protects your rights. So if your employer does anything to you, because you're a parent that's about to take a leave, because you're pregnant and are about to take a leave, you call me right away.
All right, we'll get into a short break. Lots more to go, Lior, including a question from terminationquestions.com, which you can use anonymously anytime. That and a little later on, we're going to get to our employment law rapid fire. That's on the way as well. And the phone numbers we get into a break, 1-855-821-5900. And we continue with more of the Employment Law Show. Stay with us. People think contractors aren't owed severance. EmploymentLawyer.ca says that is a myth. Many contractors are actually employees and are entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca. How do you force insurance companies to pay long-term disability claims?
Insurance companies deny legitimate claims all the time. They're playing the odds. They know that most people are just going to walk away.
Your insurer may ignore you, they may even ignore your doctors, but they can't ignore us.
We know how insurance companies work. We know their weaknesses. We know how to use the legal process to force them to pay you what you're owed.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you are only owed 2 weeks' pay when you lose your job. EmploymentLawyer.ca says that is a myth. You may be owed much more than 2 weeks per year. Don't settle for less. Always check with the employment lawyer first at EmploymentLawyer.ca. And we're back. More Employment Law Show to go, Lior. More questions to be answered. This time it's from terminationquestions.com. You can use that any time as well. Maybe your question will appear on this show. For sure. Here we go. It says, Lior, my wife submitted a resignation letter effective immediately, but her employer has refused to accept the resignation and insists her contract stipulated she provide a month's notice. Is she held to these terms, as it seems a bit unreasonable if she'd like to begin a new position?
Well, it may be unreasonable, but the time to deal with the unreasonable aspect of it is when you sign it, not after. So generally speaking, the best advice I can give you is if you sign something, you have to be prepared to live with it. So yes, if you sign an agreement that says, I'm going to have to give you a month's notice, 6 weeks notice, 3 months notice, if I resign, you have to abide by it. And sometimes that could cause a problem. But if you don't abide by it, there may be liability. So let me explain that. Generally speaking, it's going to be very difficult for an employer to do something if you don't give enough notice. But if by your failure to give enough notice, the company has incurred some financial losses that they wouldn't have incurred had you given proper notice, that they can go after you, they can sue you for their losses. As a practical matter, that's going to be very difficult for the company to prove. So in most cases, a company may actually not have much recourse if you don't give them enough notice of resignation. But that's still a risk an employee is taking. So the best advice I'm going to be able to give an employee is if you've committed by an employment agreement to give a certain amount of notice, give that notice or as close to it as possible. You are taking a risk otherwise. It may be a small risk, but it's still there. You ever want to talk about what that means, what to do about it, and if it's really a risk for you, happy to talk, so give me a call.
Want to mention you can join Lior weekly on his live stream as well on YouTube and Facebook at ST Lawyers, to reach out and join that particular program, I guess you could say. Here's the question for this week, Lior. I've been off work for almost 2 years due to a medical condition. My employer is now saying I must either come back to work or resign as they're understaffed. I'm still recovering, and my doctors, mind you, haven't cleared me to return. What can I do here?
So certainly 2 years is a long period of time, but guess what? It doesn't matter. You can be off as long as needed, so long as your doctor is supporting you, so long as you have a doctor's note, and so long as there's a potential for you to improve enough to get back to work. So no, nothing magical happens after 2 years. So in this case, the only thing that she would need is a doctor's note saying she's still working on getting better and she's not ready to come back to work yet. That's it. Her employer cannot let her go in that situation, certainly cannot make her resign. By the way, an employer can never make you resign. You're the only one that can decide on your own if you want to resign. So certainly that can happen. They can't threaten her. They can't push her. They can't punish her. None of that can happen. So going back to that powerful tool that you have, which is your doctor's note, get that doctor's note, okay? So you can be off for a month, a year, 2 years, 10 years even, as long as, again, the doctor's supporting you and there's potential hope for you to come back to work. If the doctor's saying, no way you're ever going to come back to work, that may become a frustration of contract, and the company may be able to let you go with minimal compensation. But as long as there's hope to come back to work, there is no time limit to how long you can be off.
All right, a few minutes to go, Lior. Let's get into this. It's time for the employment law rapid fire. Rapid fire question number 1. Should fired employees turn to the government for help with severance pay?
We're going to do this on rapid fire. I can spend a whole show talking just about this.
Yeah.
So the answer here is no, no, no. Government cannot help you get your severance, your full severance. The government is only able to help you get a tiny portion, your minimum severance. So you cannot go to the government if you lose your job. In fact, just by going to the government, you may be actively foregoing your full severance. So no, you can speak to me. You don't like me, speak to an employment lawyer. But what you cannot do, okay, you cannot do ever, 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 is go to the government if you lose your job in the hopes that they can help you get your severance.
Rapid fire question number 2. Do employers have the right to track employees while using equipment? We're talking laptops, vehicles, possibly. What do you think?
Generally speaking, the answer is yes. An employer can track what you do during work hours and during work time. Now, your employer can't extend that to tracking where you are, what you do outside of work. But if there's tracking devices in the car that you drive, the work car that you drive, or on your laptop, or there's a camera in your workstation, not comfortable, certainly I wouldn't like it, but an employer can do that, again, so long as it's limited to what happens at work. They can't have you check in with them, or they can't have anything on your home computer that's active when you're not working, but anything at work tends to be generally fair game.
Okay, Lior, rapid fire question number 3, and this one creates all kinds of confusion. Every week we talk about this on the radio show. Are management employees entitled to overtime pay for management?
So generally, managers are exempt from overtime. So the answer is no. So if you're a true manager, you have managerial responsibilities, you don't get overtime. Now, what I want you to remember is just because you have the title of a manager, that does not make you a manager. So if you have the title of a manager, but you don't actually perform managerial functions, you're not a manager, meaning you're still owed overtime. So a company can't get around overtime by calling someone a manager, but a true manager is exempt from overtime.
Question number 4, as we roll on here, rapid fire, can employers deny vacation requests?
Yes, so an employer can deny vacation requests. The only one that can decide when vacation is taken is the employer. Now, in many cases, employers don't use that power. They allow you to say when you want vacation, and they work with you. But an employer can deny vacation. An employer can even tell you when to take vacation. So yes, the employer has that power.
Next question, should employees file complaints regarding bullying in the workplace with their supervisor and/or HR?
Absolutely. Tell your employer if you're being harassed, being mistreated, being bullied. Let them know so they can do something about it. That shifts the responsibility to the employer.
Can you get fired for not signing a new employment agreement?
You can be fired for not signing a new employment agreement, but sometimes that could actually be a better thing than signing and then being fired. If you're going to lose your job, you don't want to have signed an employment agreement because that means you have the full protection of the law.
One more rapid fire question here, Lior. Do you have any right to severance pay if you miss the employer's deadline?
Severance deadlines are meaningless. Your rights don't expire Friday. You have 2 years to pursue those rights, so don't worry about severance deadline.
Got it all in. That's rapid fire for this week, pal. Thank you so much, and thank you for contributing to the show. Reach out now anytime, 1-855-821-5900, help@employmentlawyer.ca, and that website, pocketemploymentlawyer.ca too. We'll catch you next week right here on the Employment Law Show. Thank you so much.